माननीय पी चिदम्बरम जी।
Mr. Deputy Chairman, when I rise to speak in this House, I have to remind myself that this is Parliament, the highest seat representing the sovereign power of the people. We gave ourselves a constitution. We are bound to honor the constitution. But I'm sad to say, I deeply regret to say, when a bill like this is moved and passed in this House, we are wittingly or unwittingly breaking the Constitution every day. I know that this bill has been approved by the Cabinet of the Government of India. I know that this was introduced in the Lok Sabha. I've read that several suggestions were made in the Lok Sabha to amend the bill, to refer it to a standing committee, to refer it to a select committee. But I deeply regret that not one suggestion was accepted by the government. The bill has been passed as it was introduced, and I'm afraid, given the current circumstances, it will be passed in this House also without taking into account any suggestions. What is wrong with the suggestion of my distinguished colleagues who said, refer this bill to a select committee, refer to this bill to a standing committee? If we can wait 102 years to change a bill of 1920, why can't we wait for 102 days for the bill to be brought after examination by the standing committee? What did not happen in 102 years is not going to happen in 102 days. Sir, I want to know who's taking ownership for drafting the bill. Ownership for the bill is the Cabinet of the Government of India. But who is taking ownership for drafting the bill? And I'll explain why this bill is extremely defective, apart from being dangerous. Firstly, sir, this House must know there are existing laws on identification of prisoners. The Criminal Procedure Code has Section 53, Section 53 capital A, and Section 54. They were introduced in 1963, not in 1920, 1963. There is the other bill which the Honorable Home Minister referred to, the Identification of Prisoners Act 1920. There is also another bill which is pending, the DNA Technology Use and Application Regulation Bill of 2019, which I believe has been reported back to the House. Now, why is the DNA Technology Regulation Bill kept pending since 2019, and why is this bill being introduced? What have you found lacking in the Criminal Procedure Code? What have you found lacking in the DNA Technology Regulation Bill, which is sought to be made up by this bill? So the statement of objection reason says, and I summarize it in 3 sentences, to expand the ambit of powers, to use modern techniques for body measurements, and 3, to provide legal sanction. And these are harmless words. The harm, the mischief lies in these sections. Let's look at these one by one. I want to ask the Honorable Home Minister and the Treasury benches, have you considered the development of law in the last 20 or 30 years, and especially since the year 2010? The Constitution is a living document. Its sole interpreter is the Supreme Court of India. We can make law, but what we made is interpreted by the Supreme Court. While the privilege of making a law belongs exclusively to Parliament, the power to interpret the law exclusively belongs to the Supreme Court. That is the division of powers. Has the government taken into account two historic judgments of the Supreme Court in the last 10 years? The first is a judgment of Selvi, was a state of Karnataka, pronounced on 5th of May 2010. And the second is the Justice Puttaswamy, was a Union of India judgment, pronounced on 24th of August 2017. Selvi says, and I'm not going to quote copiously, Selvi says, while examining narco-analysis, polygraph test, and brain electrical activation profile, commonly called BEEP. Kindly remember these three words because I will refer them again. Narco-analysis, polygraph test, commonly known as lie detector test, and brain electrical activation profile. And the court said, in our considered opinion, subjecting a person to the impugned techniques, these three techniques, is an involuntary manner violates the prescribed bounds of privacy. In the light of these conclusions, we hold that no individual shall be subjected to any of the techniques in question, whether in the context of investigation, in criminal cases or otherwise. Since 2010 in this country, the law in this country is narco-analysis, polygraph test, and BEEP are unlawful, unconstitutional. They violate liberty and privacy. The second judgment in Puttaswamy's case said, an invasion of life or personal liberty must meet the threefold requirement. One, legality, which postulates the existence of a law. Two, need, defined in terms of a legitimate state aim. And three, proportionality, which ensures a rational nexus between the objects and the means adopted to achieve them. This law, which the Honorable Home Minister introduced, goes directly against the pronouncement in Selvi, and it fails every one of the three tests laid down in Puttaswamy. Let's reflect on what we are doing. What we think we are doing is not final. It has to pass the test of the Constitution. It has to pass the test of the Constitution as interpreted by the Supreme Court. And with open eyes, we are considering a law which directly violates, as I will demonstrate, directly violates Selvi and directly violates Puttaswamy. Sir, liberty and privacy are two of the most cherished rights in a democracy. Let me repeat it. There's nothing more important to the dignity of a human being than liberty and privacy, which is why the law is developed all over the world in democratic countries to protect liberty, to protect privacy. Sir, derogation of any right is the starting point of denial of that right. Erosion of any right is a starting point of extinguishment of that right. We think we are only derogating, but eventually this will lead to denial and destruction of liberty and privacy. We think we are only eroding at the fringes, but this will lead to extinguishment of all rights. Let's look at the provisions one by one. There are 4 key provisions, and I will take 2 minutes on each provision. And under each provision, I will ask a question, and I sincerely hope the Honorable Home Minister will answer the question directly and specifically. First, look at Section 21B. Section 21B of the Act allows the police and the prison authorities to take measurements. The word measurement is defined to include biological samples and their analysis, behavioral attributes, or any other examination in Section 53, 53A, and 54 of the Criminal Procedure Code, which refers to such other tests. I hope the link is clear. Measurements in this law, this bill, has 3 components, but the third component refers to the Criminal Procedure Code, which says such other tests. So the such other tests must be read into this section. Now I ask a specific question, and I pray for a specific answer. Do these measurements include narco-analysis, polygraph test, brain electrical activation profile, and psychiatric examination? If they are not included, let us make it clear. If they are included, let us make that clear. Each one of these is unlawful. And if by measurements, if by biological samples and their analysis, by the phrase behavioral attributes, and by the phrase such other tests, you are including narco-analysis, polygraph, beep, and psychiatric examination, this bill is unconstitutional. Let's take the next section. Section 3. It starts by saying any person. That includes all of us. Any person. Now tell me, I ask honorable members, I wish I could speak in a lighter vein. I ask all members in this House, active political person, trade unionist, social activist, a progressive writer, has anyone not violated any law in this country? When the police say there's section 144, you can't proceed, and you take 2 steps forward, you are violating a law. If there's an order that you shall give security for good behavior, and you don't give security, you are violating a law. And the punishment for many of these offenses is 200 rupees fine, or 500 rupees fine, or imprisonment up to 1 month, or fine. I ask most humbly, is there anyone in this House who has not violated a law? I ask the Honorable Home Minister, who has had an active political career, have you never violated any law? Now what does the section say? The section says, any person convicted of an offense punishable under any law. So even if you are convicted of an offense where the punishment is 100 rupees, this law applies. If a person is ordered to give security under section 107, 108, 109, 110, 117 for keeping the peace, for good behavior, you are violating the law. If you are arrested in connection with an offense punishable under any law, if a bus driver strays from the bus lane in Delhi, he is violating a law. Detained under any preventive detention law. Is there any member of the Communist Party of India, the Communist Party of Marxist Party, who has never been detained? Since A.K. Gopalan, preventive detention laws are there in this country. And this is any law, any punishment, detention, not a charge, arrest, no charge, even for arrest, for detention, for order to give good behavior, any law, if you are arrested, this law applies. So tomorrow, if the members of the All India Trinamool Congress or the Aam Aadmi Party or the Congress Party march from Gandhi statue to Vijay Chowk and the police stop you, they can arrest you. And the moment they arrest you, they will take all your fingerprints, your DNA samples, or behavioral samples. That is the law. Let the Honorable Home Minister say, this is not the law. These sections will be excluded. Then exclude them. And the question is there any person in this house who can say, I've never violated any law in this country, or I will never violate any law in this country? We are not talking about heinous crimes. We are talking about simple laws like order to give good behavior. The third section is section 4. Section 4 says, store, preserve for 75 years and share and disseminate such records with any law enforcement agency. My third question is, who is the law enforcement agency? A law enforcement agency is not defined. Literally, simple, plain English language. Law enforcement agency is any authority enforcing any law. Now, what does that mean? A panchayat enforces the Panchayat Act. A municipal officer enforces the Municipal Act. The health inspector enforces the Food Safety Act, Food and Drugs Act. So, a panchayat is a law enforcement agency. It doesn't define law, it doesn't define agency. So anybody who's got a law to enforce the law, to apply the law, to implement the law, will get the measurements. He can ask for these measurements and it will be given to him. Is this the intention of section 4? Why don't you define law enforcement agency? Why do you say law enforcement agency? Any agency which enforces any law will be covered. The last is section 5. Now, a person is required to give these measurements. That is the first section. Section 5 says, magistrate may direct measurements to be taken, and such person shall allow measurements to be taken. If he refuses, police officer may take the measurements, and if he obstructs the police officer, he is punishable for an offense under section 186. I ask myself, can these measurements be taken without my consent? Can these measurements be taken against my will? It's not clear whether section 2 which obliges a person to give the measurements, read with section 5, which empowers a magistrate to pass an order directing him to give the measurements. If both are read together, then this is involuntary confession. This is involuntary testimonial compulsion. This is directly violative of Article 20 and Article 21. This directly violates Selvi. This directly violates Puttaswamy. Finally, sir, there are more questions. Has the government been told that the European Court of Human Rights has held that fingerprints, DNA profile, and cellular samples and their retention, storage without consent violates human rights? That's the European Court's ruling. Does the government know that there is no scientific basis, and I say this on authority, there's no scientific basis to presume that any of the measurements, including handwriting, fingerprints, is unique to a person? Does the government recall that UIDAI filed an affidavit saying 6% of fingerprints under the Aadhaar scheme failed, the results failed? Does the government know that in the iris scan, the UIDA admitted that the failure rate is 8.54%? Does the government know that the President's Council of Advisors on Science and Technology in the USA has advised the United States government that DNA analyses are neither valid nor reliable? This is the state of science today. And you are saying science is impelling us to pass this bill. Sir, this bill is unconstitutional. This bill is illegal. We are deceiving ourselves if we believe that we are passing a bill. This bill has a huge net which can embrace anyone in this country, and you know what happens when a law of this is applied. The worst sufferers will be the disadvantaged, oppressive, and the oppressed and the poor. Sir, I oppose this bill. I ask this House to reflect. Since we won't have time to reflect today, I beg of you, send this to a standing committee or send this to a select committee and let them examine and come back. What has waited for 120 years, 102 years, can wait another 102 days. Thank you.